Прошу запросити Костюка Олега Петровича.
Please invite Oleh Petrovych Kostiuk.
Добрий день.
Hello.
Розглядається питання щодо відповідності
We are
кандидата на
considering the issue of compliance of candidate for position of HAC, Oleh Petrovych Kostiuk, with criteria envisaged in Part 4, Article 8 of the law on HAC. We have Robert Broekhuizen, the chair of the PCA Norman Aas, Mary Kay Butler, Gabriele Jodkaite-Kraskiene remotely, John J. O'Sullivan, and Jessica Lotz Thompson. We have also the HQCJ present here, Михайло Баганіс, Людмила Волкова, Ярослав Дух, Надія Кобецька, Олег Колюш, Ігор Кошник, Роман Сабадаш, Руслан Сидорович, Галина Шевчук. You have a right for recusals, submit motions, and challenge decisions of the Commission. Do you have any recusals? No, I don't have. And Shevchuk Halina Mikhailina is the rapporteur on this candidate. Thank you. By decision of the High Qualification Commission of Judges of Ukraine dated June 3, 2025, a competition was announced to fill 23 vacant positions of judges of the High Anti-Corruption Court and the Appeals Chamber of the Hague. Within the established deadline, Oleh Petrovych Kostiuk submitted an application to the Commission requesting admission to participate in the announced competition for the vacant position of judge of the High Anti-Corruption Court as a person who meets the requirements of Paragraph 3, Part 2, Article 7 of the Law of Ukraine on the Hague, and to undergo a qualification assessment to confirm his ability to administer justice in the relevant court. Mr. Kostiuk received higher education in the Kiev National University of Internal Affairs, majoring in jurisprudence, and obtained the qualification of specialist in law. Regarding his professional experience, he, from July 1st, 2002 to 2010, Mr. Kostiuk worked as a branch manager and lawyer at Plastic Service LLC from October 2007 to August 2014. He was a sole proprietor, and in 2010, he received the certificate to practice law. And starting November 27, 2012, Mr. Kostiuk has been practicing law as part of the law firm called Law Office of Oleh Petrovych Kostiuk. His professional experience as a lawyer spans more than 13 years as of the date of submission on the application to participate in the competition. He has not been subject to disciplinary action. By decision of the Commission dated February 4th, 2026, the overall results of the first stage taking qualification exam were approved. Based on the results of the qualification exam, Mr. Kostiuk scored 311.38 points and was admitted to the second stage of the qualification assessment, review of application materials, and interview. Mr. Kostiuk submitted family ties declaration, integrity declaration, and declaration of a person authorized to perform the functions of the state or local self-government. During the competition, the Commission sent inquiries to the State Security Service of Ukraine, the OPG, the NACP, National Police, NABU, and the Ministry of Justice of Ukraine as other public authorities, and we have received relevant replies. That's all from my side. Thank you. Basic information was provided. If you have anything to add, no, all is good. Thank you. Oh, yeah. That's correct, sure, but maybe you want something to add. No. And Mr. Robert, over to you.
Thank you, Mr. Chair. Good morning. The rapporteur in this case is Mary. Mary is on the screen. Mary, over to you, please.
Good morning. Mr. Kostiuk, thank you for your cooperation in this important proceeding.
Sorry.
Is there something wrong? Can you hear? Can you hear? Sorry. It's okay? Yeah? I can't hear you. Sorry, Mr. Kostiuk, I cannot hear you. I can't hear you.
Can you hear interpreter speaking right now?
Now I can.
Yes, but unfortunately, the interpreter can't hear Mr. Kostiuk either. So we don't have the floor sound from that room.
Something's wrong with the microphone for Mr. Kostiuk.
Включений.
Now it's on. Now we can hear him speaking.
Okay, thank you. So good morning, Mr. Kostiuk, and thank you for your cooperation in this important proceeding. I have a number of questions for you, and I know that you have previously provided information in response to several of these questions, but I'm going to ask again for the benefit of the public who may be monitoring this interview. I'm not expecting you to provide all the information you've provided in writing, just in answer to some targeted questions. First, you have applied for the position of a judge of the appellate court and of the Hague, if I'm not mistaken. Please tell us why you want to be a Hague judge and why you believe your experience as an attorney qualifies you for such a position.
Дякую за запитання.
Thank you for your question. So first of all, that's my attempts to continue my professional growth, let's say it so, to continue my career as a lawyer, as a legal specialist, and the position of a judge, that's the next stage. That's one of my aspirations. Why am I applying for this position? Why do I think that I am eligible to have such a position? I think that during my period of work as an attorney, as a defense attorney, I have gained enough practical skills and knowledge which allow me to be confident and qualitative in performing judicial functions of a judge of the High Anti-Corruption Court. I'm a very active practitioner attorney, and starting 2010s, I have been developing this path more and more. A major part of cases that are under my work, these are criminal cases, and so that's 70% out of 100% of all the cases under my work. That's pre-trial investigations, first instance court, appellate courts, courts of cassation, detention. So everything, that's what I have faced in my practice. It means that I have relevant level of experience and knowledge, including those cases related to corruption.
Thank you. Have any of your cases involved investigations before conducted by the NABU?
No, I didn't have such cases. My previous experience, it's not my area of responsibility. So, no, major part of my cases that I worked, I didn't have any cases with NABU jurisdictions. I had other corruption cases under Article 131, 364, 168, everything related to declarations and so on, but there were no cases with involvement of the NABU investigations.
And is the same, would your answer be the same about cases before the Hague? Have you had cases before the Hague?
No. I don't have either such experience of as a defense attorney in the High Anti-Corruption Court. I mean, specifically in this court. No, I don't have any.
Okay. So many of our questions have to do with your assets and income. And I know that you've experienced some of these questions in a prior application process, but I want to focus on just a couple of particular issues about your sources of income. Well, but first, you disclosed that you owned or had bought and sold 3 cars, 2 land plots, and 2 residential buildings during the period 2008 to 2014. But initially, you didn't provide any information about the values of these properties or the contracts governing their sale or purchase until we requested those records from you. Is there a reason that you didn't provide that supporting documentation?
Ну, причина була
The reason was the following. Yes, indeed. There was a reason why I didn't have them. So, Hyundai Tucson 2008 vehicle, in the declaration I declared it, but I failed to declare the value because documents were lost because of the long period of time. So, I bought this vehicle in the trade organization. The documents were lost. I cannot indicate inaccurate information in my declaration. That's why I didn't declare the value of that vehicle, because I didn't have documents to confirm it. Then I sent relevant request to the trade organization, but that trade organization was actually reorganized. But employees who worked there were the same. So they provided me the price of the same vehicle with the same technical details. It was something like 150,000 hryvnia. So till now, still, I don't have any documents or receipts confirming the purchase of that vehicle and the value of it. Because of my very often relocations, another car, Mitsubishi Pajero 2007, acquired in 2019. Documents were lost because of the hostilities. Then I managed to renew the copy of the document either in my phone or laptop, and this copy of the document confirming purchase of that vehicle, I forwarded to the High Qualification Commission of Judges during my participation in the competition for position of a judge in the Appellate Court of General Instance. Regarding the third vehicle, Mitsubishi Pajero, acquired in 2024, I had this information, but I made a mistake to indicate it. Maybe because so I don't have such a lot of experience to declare things, so I didn't store documents regarding all purchased vehicles. So I didn't have any reason to conceal such information, and that's why later I forwarded these documents further to the Commission and to the Public Integrity Council, and provided them with relevant documents regarding land plots in Bochaev.
Sorry, could we stop just a second with this Mitsubishi Pajero? It appears that your wife first owned this car in 2019, and then you purchased it from her in 2024. Is that correct?
ні, це неправильно.
No, it's not correct. So, as these are two different vehicles. So, the first vehicle, which was purchased back in 2019, give me a sec, I will look at the documents. So, one more sec, I'm looking for it. So, yes, now I have found it. So, this vehicle acquired in 2019. These are two different vehicles with the same technical details produced in the same year. But if you look at the WIN number and other registration numbers, you have different numbers there. 1793, that's the first registration number for the first vehicle, and for another vehicle, that's another registration number there. So these are two different vehicles. First was purchased back in 2019 for the amount of 284,000 hryvnia. further it was sold because
корозія значна.
so there were significant technical problems with it. Something should have been done, and we decided to sell it. And we purchased another vehicle to replace the previous one in 2024. So the first Mitsubishi Pajero was registered at my wife's name, another, the second one, was registered at my name. So these are two different vehicles. And
Okay.
Надавав документи відповідні.
And in 2023, you also bought a Nissan X Trail car with a declared value of 1,067,800 hryvnia. Is that right?
Це невірно, ці застереження,
No.
які зазначені.
These are concerns. No, it's not correct. So these concerns mentioned in the document of the TSO, I mentioned already. So it has no relation to me. The clients 1.2, 1.7 in this document of the TSO have no relation to me. I have never owned this Nissan vehicle.
Я взагалі не прихильник.
I even so actually I don't like even such vehicle of such type.
Okay. So, again, as I said, you have quite a complicated portfolio, but I want to focus on a couple of additional things. In 2011 and I believe it's 2013, during this time period, you declared that you had owned some property from which you earned some rental income. But we don't see the rental income declared in your personal tax returns. Did you pay tax on the rental income, and how did you pay it?
Значить, в період часу, як було зазначено
So,
доповідачем,
as it was mentioned by Madam Mary, starting from the year 2007 to the year 2013, so I don't remember when actually was the specific period, but so yes, I was a private entrepreneur, FOP. So according to the tax system, I was on the unified taxation system, and among my economic activities, which I registered, there were line 69.10, legal activities, property, agency, renting out of property, and retail economic operations. And within those economic activities carried out by me, I paid relevant taxes. In my attachments to written explanations that I provided, as of March this year, so I provided you with copies. There are also copies of a tax return. And among different pieces of information, you can see also this line of economic activities registered for me as a private entrepreneur there, and what also confirmation supporting documents that I submitted tax returns to the tax administration. So I paid taxes according to legislation and in the volumes that shall be there.
So that was one of the entrepreneurial activities I had.
Now I want to ask you some questions about your liability to your law firm. You declared that in the years 2022 to 2024, you borrowed 454,500 hryvnia from your law firm. Is that correct?
Ні, не було, ця інформація не відповідає дійсності.
No, it is not true. I cannot borrow loans from a law firm. That law firm and I never took loans.
Did you lend money to your law firm in that amount?
Нікому не даю і не беру позик.
I never lend and I never borrow money. This is a position that I have.
Was there some other way in which your firm borrowed money?
Я ще раз кажу, я ніколи, моя
I will
фірма
say it
ніколи
again.
нікому,
My
і
law firm,
адвокатське бюро, і те об'єднання, в якому я є членом, ніколи
and the
не
association
брало
where I am a member,
гроші.
never
І,
borrowed or
відповідно, я як засновник
lent
також не маю
money.
необхідності немає. В мене
And as a
немає
founder,
фінансових
I
проблем,
don't
щоб
have
дотримуватися
such
цього
a
кошту.
need to borrow money because I don't have financial issues.
Okay. Now, throughout your reported financial activity, you've declared that there are at least two sources of income, one of which includes that your mother-in-law provides your wife, her daughter, during the period 2003 to 2021, approximately 4,000 euros per year. Is that correct?
Так, це відповідає дійсності.
Yeah, this is true.
Моя матір, ну, в мене більше джерел.
My mother, actually, I have more sources of income from my attorney's activities,
Yeah,
my law firm, and
first I want to focus on this supplemental income from your mother-in-law and your mother. So with regard to your mother-in-law, you provided a list or a document that showed payments she has received in her role as caregiver in Italy. Is that correct?
Да, це правильно.
yeah, this is true.
Okay. And in many of those years, 4,000 euros would be more than half of her income. Is that right?
Ні, це не понад половина.
Well, it wouldn't be more than half. It would be less
Ті документи, які надала вона, це ті
because
документи,
the documents she provided are the ones she had kept. This is not a comprehensive list of documents. The information that was given by the mother-in-law and by my mother, they earned 1,200, 1,300 euro per month. They had 5-day working week, and on Saturday and Sunday they lived in those families and they were paid. Well, objectively, I understand that about a third. It was about a third of her income. And my mother, same thing. They worked simultaneously.
Could we focus first on your mother-in-law? But does she provide funds to anyone else that you're aware of from her earnings in Italy? Your mother-in-law.
Ну, там ще ж син є. Тобто,
Well, she's got a son,
і в неї є брат.
so she has two children, my wife and a son of hers. So I believe that her son also got some assistance from her.
So 4,000 a month to your wife plus some amount to her son out of the earnings that you disclosed. Is that right?
Ну, це дохід, це залишок, який задекларував на момент подачі
This is the remaining sum that I declared in the reporting period. And we have a joint family budget. We don't separate my wife's income, my income. So the declared sum included the gifts from the mother-in-law.
Okay, but at the same time, your mother-in-law purchased an apartment in Chernihiv for 358,585 grivna in July of 2021. Is that right?
Так, було. Вона останній раз допомагала дружині.
That is true. The last time she assisted my wife in 2018, and I stated that. Later on, she accumulated some income and bought an apartment, yes. Because the financial assistance was not allocated on her part.
So her
And then in
contribution-
2020,
Sorry.
and then in 2024, she gave another gift.
Okay, and at the same time, your father-in-law acquired a residential building of 153 square meters in July 2022, for which we don't have a value. Is that correct?
Ні, цей будинок,
No.
чесно кажучи, я не знаю,
Well,
цей будинок.
to be honest, I don't know.
Сім'ю, він вже
When
будувався.
I
Цей
entered
будинок
that family,
будувався
that
на протязі-
house had been
зараз
already
будувався на протязі останніх
had been
20
being built,
тобто
and
матеріали,
it was being
будівельні
built,
матеріали
has
з
been
того, що
being
за
built for
радянських часів
25 years,
збиралися. Це саме-
and
саме
they collected
збудований
construction
господарський
materials
спосіб
from the
будинок
Soviet
за рахунок
era,
коштів тодішнього
and
подружжя.
the construction is made by the
Плюс
my father-in-law.
теж ще були ще живі, допомагали. Тобто це збудовано на протязі тривалого часу. Це не придбане.
That house was being built for a long time. It was not bought that year. Maybe it was registered in 2022, the ownership title, but I'm not really knowledgeable about it. But it was built with the owner's own resources.
Okay. And then with regard to the support that your mother provides, you disclosed that she has been providing to you approximately 4,500 euros per year from 2006 to 2021. And then you also provided a document that said that from 2011 to 2013, she provided 25,000 euros approximately. And again, what is the source of your mother's income out of which she provides this financial support to you?
Ну, таке ж, як і у тещі, вони працювали в один
Well,
період.
the same source of income as my mother-in-laws. They worked in Italy at the same time. They lived in families. They didn't spend virtually anything.
Проблема, що батько помер, і матір
Then
вирішила
my father died, and my mother decided to help me to build my own house, and my brother will inherit the house where she lives currently. So she decided to share the future inheritance between us, and this is how she assisted me in building my home.
Кошти походять за рахунок
And
здійснення фактичної
the costs
діяльності.
come from her activities
Ми похилого віку
as a caregiver in Italy, and I provided you documental proofs. And from March, the last contract, it turned out that the last contract, her working contract, so I actually sent it to the PCIe, and I have a copy in English.
You used these funds which you received from your mother to buy your home. Is that correct? Your residence?
Ні, я його будував господарським
No, I didn't build it. I
будував.
constructed with my own resources.
Okay.
I have done it from 2011 to 2013.
Okay. And does she provide annual support to your brother as well?
Я з нею з'ясовував, як відбувалося. Вона
So I did not actually learn the details of that. From 2011 to 2013, she didn't help my brother because we decided,
в такий спосіб допомогти мені побудувати.
she decided to help me build my house. So she may have given him 1,000 maybe, but mostly she helped me. And she told me that before the interview. But as a general rule, she helped me and my brother.
And the only, except for the last contract that she has, the only information we have about her income in Italy comes from the declaration that she provided. Is that right?
Не з декларації. З декларації
Not from her declaration. According to her declaration, you can only see her Ukrainian pension. I provided a copy of extracts from her bank records. She is a pensioner in Ukraine. That is, she is a pensioner in Italy, and she gets 307 euro as a pensioner in Italy.
Окрім української, ще італійську.
So beyond Ukrainian pension, she also gets Italian pension.
Ну і відповідно документи про право на роботу і
And
договори, що збереглися.
I also provided her right to work there and all the contracts that she kept.
Now I want to turn to another source of income that seems to be part of the basis for your real estate portfolio. You disclosed that you earned money while you were studying in the UK in the amount of approximately 14,000 US dollars as of 2000. Is that correct?
Да, я був. Да, ну, да.
Yes, that is true. I was an intern in the UK.
So, I'm sorry, so you were a student or you were employed?
Ну, студентом після четвертого курсу була державна.
After the fourth year, there was a fourth year of university studies, there was a state program for us to improve our practical skills. And I, back then, could drive a truck, and I worked at farms there. And officially, we got our salary, we were housed. Lodged.
So in 1 year you made $14,000 in profit in the UK in 2000. Is that your statement?
Ну, да, ну я працював.
Well, yes. And I worked from 4 a.m. to 8 p.m. Yes, that is true. And I had a goal to earn money to build my own home. I was already married.
Okay, I want to turn your attention to your 2024 and 2025 declarations. You've already explained what's happened with the Mitsubishi Pajeros, but in March of 2025, you purchased a 2011 Lexus RX 350 for 650,000 hryvnia. Is that correct?
Да, це відповідає.
Yeah, this is true.
And what was the source of funds for this purchase?
Ну, продав я машину.
Well, I sold my car.
Зараз я там розрахунки надавав.
And I provided you the calculations. Let me see, just a moment. Pajero at 2004, 350,000, then income from attorney's activities, income from leasing activities, and the remaining sum from the previous periods. And generally speaking, it was enough money.
I'm sorry, what were you leasing in 2024 and 2025? You said leasing activities.
Ні, не в 20-му, в 24-му році.
In 2024, that is, in 2025, I leased an apartment that I had bought after I came from the United Kingdom. That was a 3-bedroom apartment, and I mentioned it in the table. 63 square meters, 60,000 of income. And I provided that following the request from HKCG PCIe.
Okay.
Сукупний дохід.
So the general income of 1,200,000 per year.
That's the combined income of yourself and your wife, plus these other sources, leasing income from your mother-in-law and your mother. Is that correct?
Да. Значить,
this is
залишок
correct.
готівки станом на
So remaining
31-12
cash
року було
as of late 2024, $3,000, the remaining cash in euro, 17,000 euro, then a gift from a mother-in-law, 2025, 4,000 euro, remaining cash in
нашої спільної 30 тисяч гривень, заробітна плата
2024, 30,000, then
350 тисяч оренда квартири,
sale of
60
Pajero,
тисяч заробітна плата моя,
then my
плюс
salary,
дивідендів,
my wife's income,
73, 190,
my salary with dividends.
ну, в сукупності мільйон.
So the combined sum was 1,311,000,
податків 1 мільйон
and after taxation 1,187,000 hryvnia.
My information is that in 2024, you declared that you also have investments in 3 limited liability corporations, and that you invested in 2 of them 2.2 million hryvnia back in 2016. Is that correct?
Ні, це не відповідає дійсності.
No, this is
Відношення
not
до мене,
true.
ці пункти застереження
So-
ніякого немає. Я нікуди нічого не інвестую. Я інвестую
I
тільки в
didn't
нерухомість.
invest anything anywhere. I only invest in real estate. I don't have any bonds or obligation or something, or shares.
So is there someone who has the same name as you?
Я не знаю, це там, я дивився громадську...
I don't know.
Зараз, секунду, я відкрию.
Just a moment. I will
Зведення.
give you an answer. I'm looking something up.
Ну, я інвестиційною діяльністю взагалі не займаюся.
So
Мені
I'm
це
not
не
involved in investment activities. I'm not interested in this.
Там моє прізвище.
Okay.
Ну, йде,
So-
от, Валентин
And my surname.
Володимирович, ну,
So here you have Valentin Volodymyrovich. That doesn't relate to me in any way.
Я в поясненнях там
And
написав.
I stated that in my explanations.
Омелян Lawyers, торговий дім.
Omelian Lawyers,
Там прізвищ моїх
Granite of
немає.
Ukraine.
Це відношення до мене
There are
ніякого
even
немає.
no
Ніяк.
surnames like
Це просто
mine
появилась
and doesn't
інформація
relate to me.
відносно іншого можливого кандидата.
So it may relate to a different candidate.
Це помилка.
So a CSO's application related to a different candidate. This is a mistake.
Okay. I guess it's maybe I have a different relationship with my parents, but your mother and mother-in-law work for a few thousand euros per year to help provide you with a Lexus worth 350,000 hryvnia. Do they understand that their work as caregivers provides you with such luxury items?
Та Lexus я купив за власні кошти,
Well,
зароблені
I
мною
bought
за-
Lexus with my own money, with my income for 2024, 2025. And my mother no longer works. She hasn't worked for 3 years. My mother-in-law does work. So that car was bought with my own money, with my that is with my family's budget.
Understood. And my last area of questioning has to do with border crossings by people to whom you're related. In particular, someone I believe is your nephew, Yevgen Kostiuk, crossed into the territory controlled by the Russian Federation 49 times between February of 2022 and November of 2024. Do you have any understanding of the reasons for this?
Я думаю, що ця інформація не відповідає
I
дійсності.
believe that is not true because he has stayed for 3 years in Germany and he has never gone to Russia, to my knowledge.
So your understanding is that he hasn't even been in Ukraine from 2022 to 2024?
Ні, в Україні він був, но наскільки
No,
мені
he has been in Ukraine, but to my knowledge, well, we don't have a common family. He's not that a close family member, but he hasn't gone to Russia and he didn't have such a need. He lived with his parents in the western part of Ukraine, and there are no exits to Russia there.
кордону з Російською Федерацією навіть немає.
There is no border with the Russian Federation there. So this is not true.
Is that what you're saying? This must be someone else, not your nephew, Yevgen Kostiuk.
Можливо, буде, ну, інформації.
Maybe. So the information in my case file does not contain any information regarding my nephew. So for 3 years, for sure, he has lived in Germany, but he could travel outside Germany too.
So do you also have a nephew, Vladislav Kostiuk?
Да, є. Син мого
Yes,
брата.
I do. This is son of my brother.
So there are records of border crossings by him 22 times between August 3rd, 2025 and December 24th, 2025. Do you know why he would be doing that?
Ну, він там працював з
He
перевезенням
worked there. He was doing either cargo or passenger transportation. That was done on the border, on the Polish border. That was related to his professional activities.
Робочий аспект. Ну, наскільки мені це відомо.
To my knowledge. But no one went to Russia for sure from our family.
Okay. So to your understanding, there's nothing about relations with the Russian Federation that might reflect badly on you if you were appointed to the Hague.
Ні, немає, це 100%.
No, there are no such relations.
Okay.
100%.
I think.
У мене навіть закордонного паспорта немає,
I don't even have a foreign passport. I'm embarrassed to say it, but this is like this.
I understand. You know, so some of our questions are issues raised to us by civil society organizations or others, and we want to give you a chance to explain what you know and what you want us to understand about that. I don't have any other questions at this time.
Thank you, Mary. Just looking at my colleague. And on the screen. No, thank you, Mr. Chair. Back to you.
Thank you.
Добре. Шановна пані Галина, що у вас є питання? Будь ласка.
Dear Halina, do you have any questions? Thank you. So, several questions to you, and we have discussed many of those with the PCIe rapporteur, but nevertheless, we have some left. In 2024, you reflect your declaration the sum of income from entrepreneurial activities, 24,434 hryvnias. Which year was it? This is a low amount. You can look it up. Can't be. I'll look it up. 2024. It could be 240. Just a moment. Dividends. You define your dividends. So 24,434. It may have been a typo. 24,000, maybe it is correct. I'm not ready to give an answer. Well, whether it is ready or not, this is in your tax return. Well, it may have been a typo. It can be a typo because it is reflected in your tax return when you provide information. Well, is it 2024? Yes, it is. Why is your income so low? I'm not ready to tell you, but I'll look up my tax return. I printed out my declarations regarding my law firm. So I had activities. So as you're looking up, in 2024, what were your activities? How many cases did you have approximately? Well, so I made a note here. 2026, 2024. So the number of contracts and instructions. So you don't remember? No, I don't remember. The only thing that I can say, I have from 15 to 30 cases on a regular basis. Okay, that's great. So your income is 24,000. What we found in the open registers, we can establish, and with your participation, we established that 28 court cases. Is this amount? Is this number of cases worth this amount? What are your tariffs?
The major part of cases I provide based on the Free Legal Aid Center. All money are transferred to the law firm, and I submit and all information regarding them. So, okay, your information is clear. Then let's go back to financial aid received from your mother-in-law. So, informed the commission that your mother-in-law helped your wife, son, and just mentioned that their family, your parents-in-law, they are also building the house. No, it has already been built. Okay, at that moment they were building the house when they provided aid to your wife. Is it right? Look, when I joined this family, the foundation and walls were even there. No, don't tell me what was there. No, don't tell me that. I'm asking about financial aid provided your mother-in-law to your wife and her and also son, that the house was being constructed at that moment. So there are still ongoing some exterior works. So no, but it has already been commissioned. Okay, it has been commissioned, but it requires some investment still to finish everything completely. Then another question: was it enough for your mother-in-law to cover your basic needs, livelihoods? If she invested into construction of the house, she was helping her daughter and son. So it was enough money for her. Yes, it was enough money. And you accepted this help. No, it was not me. My wife accepted that help from her mother. Okay, clear. Then let's go back to financial aid, either of your mom or her, in the amount of $25,000. Tell me, when your father died, back in 2010, on 5th of June 2010. Okay, have you inherited anything? No, I have not inherited anything at all. Then, why did your mother provide you with $25,000? You said that it's for your future. She decided to do like this, to divide inherited property. No, but she's still alive. That was her decision. I can't do anything regarding the decision that she made. She made such a decision in order to avoid any potential future conflicts. A person she is. Okay, so she managed to accumulate $25,000 along with helping yourself and your brother. No, it wasn't. This sum was not given as one-off payment. It was during different years, from 2011 to 2015. Okay, do you have any supporting documents to confirm that such money were provided to you? No. I don't have any documents. They were provided to me in cash. Okay. And do you have any financial supporting documents that your mother-in-law helped each year to your family with an amount of €4,000, give or take? She gave it to her. I was present there. Documents. No gift deeds were registered or processed. Okay. And I found some data regarding 2024, the law firm income, 94,000 of that was for law firm income in 2024. I think that it was that you asked before. Okay. When you filled in the questionnaire applying for participation in this competition, you failed to indicate information that you also in parallel participate in another competition. Why? Did you fail to indicate this information? Maybe it was a mistake, because I don't have much of experience. I cannot recall it right now. Okay, lack of experience, and maybe not, because you are an attorney who has so many different cases. No, I don't know. I don't remember why. Okay. Yeah, filling in the questionnaire is quite a challenging task. Okay, if you say that you don't have enough experience, then why in your motivation letter, both for the competitions of the General Court and to the hack, so why in your motivation identical? Is it also because of the lack of experience? No, it's not because of the lack of experience. These courts actually differ from one another with one important element, and that's a subject and the topic which they cover. Both general courts and high anti-corruption court, they consider criminal cases, but for the high anti-corruption court, it's identified as a specialized court related to specific subjects. And I have only one motivation, and I indicated it also in my previous interviews. So, okay, clear. You didn't think that you shall at least describe all your motivation letter, why you would like to become a judge of the hack. So actually, that's quite an important court. So for you, motivation is the same for both types of courts. You just copy-pasted it. No, why is it so? No, I'm just asking, because you've got my question. Yeah, the motivation was the same. You didn't change it. Everything is the same, just copy-pasted. Okay, let's go to the next question. Regarding your work abroad when you were a student, as you are telling us that you managed to accumulate those savings and earn such amount of money. So tell me, how many hours per day did you work? I provided in my explanations. No, in a nutshell, my personal working day started from 5 a.m. in the morning. So I'm asking you, how many hours did you work per day? Or would you like us, the Commission, to calculate it? 12 hours per day for sure. Okay, 12 hours per day for sure. That's your working timing abroad. Tell me, as far as I know, in the UK, they have some labor rights, and they usually are indeed compliant with such labor rights. So did your employer agree on you working 12 hours per day, as you described in your explanation, specifically you driving a vehicle, using a vehicle? You know, that's another issue, whether I agreed, and I agreed on working like this. Okay, you agreed, and what about the employer? The employer just suggested it to me because they needed employees. But did they violate rules? I don't know. I don't know their legislation. I don't know whether it was a violation or not. Okay, I've got your point. Thank you. Tell me, back in 2016, one citizen, I'm not going to tell out loud the name of the citizen, who was a party to the criminal proceeding, submitted a disciplinary complaint to the relevant center in the Odessa region as they thought and observed unethical behavior of yours in your work. And based on the decision, based on that motion, there was a decision made to open the disciplinary proceeding. So why didn't you tell about the station when you applied for the competition? Explain now, please. So there was murder. There was a murder. 2 persons were killed. He was a victim. His relatives were killed. And during the time of provision of consultations to my defendant, he interrupted our conversation, started to insult my client, calling him an accomplice of this murder. So that's actually was everything in the premises, very old premises of the court. And when I was out of the court hearing, he tried to provoke the conflict and to harm me physically. I didn't respond in any way to that situation. No, I didn't receive this question in written questions, but I have copies and originals of the motions and audio recordings of that court hearing. So the response was there. If you want, we can actually watch it and look at it further. There was a motion submitted to consideration of a court regarding his conduct like this. So de facto, the prosecutor who was present there, he also considered and admitted that such behavior took place. Further, he didn't even participate in other court hearings. So till now, you still think that the behavior of a victim was illegal. I didn't provoke him in any way. But the victim thinks that your behavior specifically was unethical. How? How was it unethical? I even was not in communication with him. No, that's what the victim states. That's why I'm asking you. That's his position. That's his legal position. So what can I do with that? Okay, then, based on all those circumstances which took place at that moment, and given the fact that you described the situation when in your questionnaire for participation in the appellate court, you gave the name of that victim, you described all the circumstances, actually. So what do you think? Did you violate the rules of attorney's ethics? No, I didn't violate. First of all, he wasn't my client. Secondly, information regarding him was publicly available, and the case was publicly available, names were there, so you didn't violate attorney's ethics. No, I didn't violate. And he actually reacted against me, it was not me who reacted against him. Okay, thank you. You have already received a question from Madam Mary regarding the loan given to other persons by your law firm, and you said that you didn't do it. Okay, but another question. Did you take any financial aid from your law firm? No, I have never done anything like that. No questions, sir. So, dear colleagues, do you have any other questions? The candidate, Ruslan, over to you. Thank you for giving me this opportunity to ask you some questions. So, Oleh Petrovych, my name is Melnik, I'm the commission member, and going back to your motivation letter, which was mentioned already by the rapporteur on your case, I wanted to ask the following. Your motivation for participation in the competition for positions of judges of the High Anti-Corruption Court, you stated as the following: not sporadic accidents of violation of citizens' rights and lack of trust and loss of trust to the judiciary at large. Okay, that is an example of cases which you are proud of. Out of 5 cases, you mentioned in particular a case where, based on an accusation regarding corruption offense related to the bribe, the defendant was acquitted. So in such a way, you showed that actually the justice was administered in a fair way. So my question to you is the following: do you think that renewal of trust to the judiciary, including your mission, you see in an increased number of the guilty verdicts regarding corruption cases, and how it will be perceived by the society, by the public, if you, as a judge, are going to make more and more guilty verdicts regarding such suspects? So the cases that I mentioned in my motivation letter, these were cases which I am proud of, or I don't know, that was not provided as to be breaking of it. No, it was like my practice, which what I do. I means the following question: do you think that that's a problem, including for the High Anti-Corruption Court, that we have not so many guilty verdicts regarding accused persons? Are you personally ready to adopt more guilty verdicts regarding such accused persons and corruption offenses? And do you think that it will contribute to increasing of a trust from the side of the public? So I'm ready to adopt verdicts which will be justified, legitimate, compliant with procedural legislation. That's my only position. Whether it will be a guilty verdict or non-guilty verdict, it depends on results of consideration of all the evidences and consideration of the case. But generally speaking, such a small number of guilty verdicts gives us a sign that it shall be increased, or what? What does it tell us? Or you don't agree at all that it's not a low number of guilty verdicts? Maybe you think that it's okay. So what's your position regarding this? You know, the number of verdicts, it's a subjective notion. If there is a guilt which is not proven regarding the commitment of an offense, it will be non-guilty verdict. It's not about objectiveness or subjectiveness. It's about offense, whether it was committed or not, whether it was proven or not, and whether indeed we can confirm that this person is guilty. So here we shall not speak about the numbers, but shall be only about legitimacy and reasoning of it. Okay, thank you. But if you become a judge of any court, if you see no difference, so let's look at the judicial statistics. Judicial statistics uses operational and operates with quantitative figures. Then you will be aware that actually they use such statistics. Vitaly, over to you. So I have a question. And regarding the practical task, number 1, the verdict or the draft verdict which you worked on, my question is the following. How do you define temporarily operation of the criminal legislation? So that's actually, so generally speaking, it's Article 5 of the Criminal Code, so that's what I apply. Okay, I will remind you very shortly, so that at the moment of commission of the crime, there was one provision active and in force, and during consideration of the case, there was another provision adopted of the legislation. So there was a higher threshold and the more severe punishment for such crime committed. So, and judges agree with the defendant attorney regarding qualification of actions of a person under Article 362 in the version of the Criminal Code as of the moment of commissioning of the offense. So we have new provision of legislation with a higher level of punishment and a higher level of threshold for application of such punishment. So what do you think? What shall be applied there? So, but look, the disposition actually decriminalizes, but the severity of punishment was increased. Yes, it was increased. The same as the level for qualification of such specific category of crimes. That's why I referred to Article 5 of the Criminal Code of Ukraine, if not mistaken, and I applied it as of the moment of commissioning of the crime. Okay. Then my next question, if we compare two versions of criminal code, and we need to understand whether a retrospective mode shall be applied or not, what we shall take into consideration? No, we shall also take into consideration other circumstances. And in your case, what is it? So that we have an increased threshold for declaring. So, you know, it doesn't decriminalize completely. Conduct of the suspect, but as that threshold was under that limit, we needed to apply the provision of legislation which envisaged softer punishment. Okay, thank you. Dear colleagues, are there any other questions? No. So, Oleg, you have a final word to address the Commission members, the PCA members. Do you have anything to say? No. Thank you so much. I was open as much as possible. And thank you for this interview. Thank you to the PCA members, to the Commission members. Everything was so easy and so great. Thank you. Thank you for participation in this interview. The interview is over and the break is announced.